Thanks for joining us on 9 News Plus. I'm Chris Bianchi. Affirmative action is the practice of including historically underrepresented groups of race, gender, or sexuality in education and employment, and its future hangs in the balance of two high-profile Supreme Court cases that are currently being heard. 9 News legal expert Whitney Traylor joins us on 9 News Plus about the affirmative action cases that are currently being argued at the Supreme Court and whether or not affirmative action could be overturned altogether. Here's my interview with Whitney Traylor.
Well, affirmative action is the big debate right now at the Supreme Court level. Whitney, I kind of want to start by asking you if you could describe the case that's currently being heard by the Supreme Court.
Right, so the Supreme Court, this is a case from essentially two lower court cases. So there was one that started at Harvard where a group of Asian American students challenged Harvard's policy, which we'll get into, and then there was a group of students who challenged the University of North Carolina's policy. Both of those policies took race into consideration, and the plaintiffs essentially said this discriminates against, in one case, the Asian American students, in the other case, the white students. And so these cases were both accepted by the U.S. Supreme Court, and so now the Supreme Court, by accepting writ, will make a decision on essentially whether race can be a factor in college admissions. And we can go through the history because there's been several significant cases really since 2003 that the courts evolved on this. And so now the court has heard argument on these cases and will rule, even though they stemmed from two different cases, the ruling will obviously apply to the whole country. And so we're waiting for the court to decide what it will do as it relates to race in admissions.
And what do we know based off of those cases so far? I know there's been, we can kind of glean from some of the questions as to how the justices may be leaning. What have we learned so far?
Well, we know that it's a very conservative court, and they've demonstrated its propensity to move to the right, which is it has done so really over the last 20 years, and more specifically really over the last 5 years. And so based on the questions, a lot of people are saying that they're anticipating that the court will overturn really its precedent. And we're looking at the 2003 Grutter case, and then in 2015 the University of Texas at Austin case, in which both of those cases the court, even though it was very somewhat specific, said race could be a factor, and in UT the court upheld the policy. So here folks are expecting the conservative court to overturn that precedent.
Correct me if I'm wrong. It's the 14th Amendment, right? The Equal Protection
Correct.
Amendment, which was put in after the Civil Rights, which was intended to equal access. That's the basis of the argument, right?
That's exactly right.
For people challenging the case. Could you get into more detail on that? Because again, I've got a top level knowledge on that.
Right. So the 14th Amendment Equal Protection Clause says that the government has to treat people the same. And if it treats people differently, men or women, black or white, it has to justify it. And based on the reason in which they're making the decision will be the level of scrutiny. So for example, if the court on commercial and the economic things, that's a low level of scrutiny. So if the court says, hey, this grocery store can advertise on TV all day long, but this adult entertainment industry, they can only advertise at 1 a.m. because kids may be watching that. So that is where the government regulating who can put on a commercial is treating people differently. They're treating the adult entertainment industry one way, and they're treating grocery stores another. But that's easy to justify because the government could say, well, we have to protect children from this, kind of seedy type of activity, right? So that's the argument. But when there's a distinction based on race, so for example, if the government says we're going to try and award contracts to minority businesses who have been historically excluded from business, they can still do that, but they have to justify it under a strict scrutiny standard, which means it has to be a very compelling state interest. And so here, when they're saying we're going to use race as a preference, is that allowable? The court is going to evaluate it under a strict scrutiny standard and say, yes, this is to reverse the years of discrimination, the history of discrimination, and that's really the issue, is what standard the court is going to use when evaluating this kind of case. And so some folks are saying, well, if they use the strict scrutiny, these these policies from the schools are going to be deemed unconstitutional, because they're saying, the North Carolina, for example, they're using race as part of their admissions to increase the diversity of the student body. And the argument is, you don't need to have that race factor. You will naturally have a diverse student body. So you don't need to come in and sort of, manipulate the numbers artificially. That's not really, there's an argument that show the statistics don't really bear that out, that it won't be sort of this natural population reflected,
Right.
Reflected as part of the bigger population.
How do you go? Let's say this does happen. Let's say the 6-3 majority conservative court does end up striking this down. The question I've got in my mind is, how do you actually enforce something like that? Because if you're sending in an application, you get an application in Harvard, right? You see on a piece of paper that somebody is X race, right? And how do you go about enforcing that? I guess, are there means for state governments to go about trying to reject this? Or
Right.
Federal governments.
And it's a good point. So first we have to establish, we're talking about government action, but Harvard, for example, is a private school. But the case law has said this stuff even applies to private colleges and universities. So they're still all governed under the same sort of standard. Now, the issue, the way you discover these things is through litigation, right? So if a white student says, wait, my numbers were higher and there were people with lower numbers that got admitted, they then file the lawsuit and you get discovery and you get the background information and you see how many people applied, what their race was, what their numbers were, and who was ultimately admitted. But see, that's one of the issues in the Harvard case, because in Harvard, the Asian American students are saying, actually, look, we're being discriminated against the Latino, Black, and white students, because they're saying just on academics, we have higher numbers than everybody else, but we're sort of intentionally not being let in, because Harvard also has this a personal rating where it's more subjective, that deals with issues like integrity, honesty, hard work, and that kind of thing.
Extracurriculars, right.
And the Asian American students are saying, well, you're arbitrarily lowering those personal scores in order to limit how many of us get in. So it's kind of goes to the question that you're asking, is how do we know these things? And that's what we're discovering in the case, is all the numbers had to be produced and everything else. And the argument the Asian Americans raised is that, hey, you're arbitrarily lowering our personal scores in order to not have a predominantly Asian American population at the school.
So walk me through how legally it might look if this conservative court does end up striking down affirmative action in this case. How could college admissions look on a legal basis in 4 or 5 years?
Right. Well, I think what it would look like is, and it's only a number, I think I read a statistic, maybe, I can't remember, it was between 40 and 60% of schools use race as part of their admissions, because you have to understand.
So it's not everybody doing it.
Correct. That's exactly right. And nobody is saying, none of the plaintiffs are alleging that somebody says, hey, you're Black, you automatically get in, right? It's just a part of a number. For example, they give you credit for coming from low income, being a first generation student. Legacy students are admitted, and legacy students are students who parents went to the school. And so legacy students are overwhelmingly admitted when they have lower scores than other people who were not admitted. So the point is, there's all these other factors that are used in admissions every day. And if race is now not a factor, then they will have to go on those other criteria. And so when they judge applicants and when they decide who gets into school, they're going to have to show that process. They're going to have to show how they got their numbers. So there'll be more litigation basically, because there'll still be people alleging, hey, you used race. There was a black student who had a lower SAT than me and got in. I think it was based on race. So you'll still see, even if the court overturns this precedent, there'll be more litigation.
So it seems like okay, again, I'm not meaning to opine here, but off the top of my head, it would strike me as an issue that if you strike down affirmative action, or in some of these cases where you're kind of trying to nudge more minority students to make the college campus population reflect that of the community at large, which I think is the original intention of affirmative action, right? That's the point of it, is that it makes it look that way. But then that would potentially give more weight to legacy students and people who may be more privileged in years past. And again, I know you're a lawyer and you're looking at this from a legal prism, but that would strike me as an issue,
that's an astute observation, but I would go back to your first point and say, no, the purpose of affirmative action, this is all a remedial action. This is to remedy the years of discrimination, because you have to remember, before Brown, discrimination, segregation in education was completely legal. That was in 1954. And it really wasn't until the 60s that schools actually started trying to implement that. So the point of a lot of these statutes, these anti-discrimination statutes, or these statutes trying to promote, or the case law trying to promote this kind of diversity, is because of the years of discrimination. And as we were talking, beforehand, for example, in my case, I was born in 1971. So my parents going to school in the 40s and 50s were effectively not allowed to go to college. I mean, schools were openly and blatantly discriminating. And then we had Brown, and then we had the Civil Rights Act of 1964, where things then started to change. So when you look at that and you say, well, just a generation ago, they were legally not allowed to go to colleges and universities, then that's the point of trying to sort of reverse that by promoting more minority participation in the schools and universities. And that's why the Grutter case in 2003, in the opinion, they said, well, this should be about 25 years. They were anticipating that amount of time to sort of
Senator Day O'Connor, I think, specifically said that when she ruled in favor, right?
That's exactly right. And so that's what some people are using, saying, well, you don't need this anymore. But the states and the schools that have stopped using race as a preference, the statistics bear out that there's less minority participation. And this is an argument. There's a subjective element. Does diversity increase the value of the education for everyone? And there's plenty of studies that show diversity in education is beneficial to all the students because it reflects society. It helps them to, be more adaptable, be better employees, that kind of thing.
Well, I guess that's the final question I've got, is that was the original intention. You just said it there. It was when Senator Day O'Connor signed off on, or the Supreme Court Justice Senator Day O'Connor, who I believe cast the deciding vote in that 2003 case to allow essentially allow affirmative action.
To allow now, and it's important to understand, because I think people have a misperception when they hear affirmative action. Some people think about quotas, or that you get a certain number, or that you're not qualified. Here, what we're really talking about is race being a factor, one factor of many, in admissions. Should it be completely race neutral, which would be difficult, because if somebody says in their personal essay, hey, here I'm an son of an immigrant, or I'm the first one to go to college, and they celebrate that heritage, the school is going to know really anyway. But the point is, can they award some points for that, just like they do when they have somebody from a town that they've never had a student before, right? They can give those kind of sort of subjective points, if you will, and now that will that may be one factor that the schools can't consider.
I guess the thing that I also want to mention too is that it's pretty clear in the 2003 case that the way the Supreme Court ruled, and correct me if I'm wrong, is basically that affirmative action is not a perfect system. It is a kind of a band-aid in a sense before society kind of improves itself. And I think Senator Day O'Connor basically said that I think in 20, 25 years we will not need affirmative action anymore. Here we are 20 years later, and a conservative-leaning Supreme Court is saying, well, that was the precedent at the time. Are we there yet is the question.
Right.
And I think a lot of people, perhaps yourself included, would argue that we're not there yet. But I don't know. That's the interesting dilemma, isn't it?
That is absolutely the dilemma is, and you have to look at these other factors then. I think if you say, well, historically, this race has been excluded from just even a generation ago. So should we or should we not include that factor? I think you have to then also look at, well, should legacy count? Because obviously legacy is going to perpetuate the same population that's had access. It's just more kind of wealthy white folks. And and that's the thing. The argument is, and some people are arguing that the Asian Americans, for example, or that the plaintiffs can't show damage by having race as a factor in terms of having the diverse student body as a general body of plaintiffs, if you will. They're saying that this does actually help everyone. And so, if the court does, some people are saying that they may limit it specifically to these two policies so that it wouldn't necessarily overturn all of the precedent allowing schools to take race. They may just say Harvard and UNC, these policies specifically were constitutional or not constitutional, or they may say, okay, race, here's a ruling going forward, race just can't be considered.
Well, I guess we'll find out next year, right?
It'll be next year before we get the opinion, because they just had an argument on Wednesday. I think it was they had 5 hours of argument, which is somewhat unheard of. That length of oral argument in the Supreme Court was extensive.
And we're talking about last Wednesday, November the 2nd.
That's correct, and it was, and that's why everyone is saying, based on the types of questions and based on the leanings of the court, they're anticipating the court's ruling against the universities. Which it's important to note that at the lower court, both universities' policies were upheld as constitutional.
Interesting. So I guess we'll find out, and again, one of those weird cases, in a sense that overlaps socioeconomic factors in addition to legal factors, but Whitney,
yes,
fascinating stuff indeed.
It is, and that's actually, I read just earlier an article from The Atlantic. One of the attorneys working on the case argued that the students that are getting in and taking advantage of the race component are of a higher economic their standing, right. And so his point in arguing why race shouldn't be a factor is because it should be about actually the lower economic, the people who don't have access, and which will include all races. So
I think that's what Neil Gorsuch said is what is diversity, right? Is it diversity economically? Is it race? What is
that's
diversity?
exactly right.
An interesting question.
That's a very interesting question, because if you have everybody you have diversity, and I think they pointed out that
I think it was Alito, actually. I think it was Alito who asked that question. What is diversity?
Right, but the statistics at Harvard, I think the top 1%. There's more folks in the top 1% economically than the bottom 60%. And so they're saying that they're really pointing to the economic factors and saying, look, if you're trying to create diversity, if you're trying to bring about the lowest economic class in the country, then it shouldn't be based on race. It should be based on economic and financial need.
Well, fascinating case indeed, but 9 News legal analyst Whitney Trailer, I'm sure we could talk about this for hours, but we'll leave it there. But thanks so much for joining us.
Sure thing. Good to be here.